We're going to be talking about mastering due diligence for M&A exits. And this presentation is focused towards founders and startups. My name's Ellisha Blechynden. I'm a corporate attorney based out of San Francisco. Our firm focuses primarily on startups, equity financings, and M&A transactions. We work with a lot of startups and small businesses and founders and VC funds and angel investors and all sorts of folks in that space. A big part of our practice is M&A transactions. So I'm excited to talk to you about this today. Like I said, as we go through, feel free to pop your questions in the chat. I'll check in on the chat every now and then. And then we should have time for Q&A also towards the end of the presentation. So here's our agenda for today. We're going to be covering quite a lot. Sorry, clicked too soon. Just trying to figure it, there we are. So yeah, we're gonna cover quite a lot. We're gonna talk about, sort of the basics of what an M&A transaction is, and apologies if we do we're gonna start pretty basic and then build up from there. And we're going to talk mostly about the due diligence process in M&A transactions, which for founders and startups, if you're the seller or if you're the buyer in the transaction, it's a big piece of work that the lawyers do a lot of the work, but the clients do a lot of this work too. So it's something that the lawyers and the clients partner on closely. So we're going to cover sort of the basics. We're going to talk a lot about what's involved in due diligence. We're going to cover some specific areas of due diligence that often require a lot of work. And then we're going to sort of talk about, reps and warranties and indemnities and how all this due diligence ties together in the transaction overall. Okay, so just to kick us off, what is an M&A transaction? So M&A, mergers and acquisitions, is the process by which companies are bought, sold, and combined. For founders and for startups, it's often the primary exit path. When it comes time for a startup to have an exit, you're either going to do an IPO or an M&A transaction. And as we all know, IPOs are very hard to do and they're fairly rare these days, whereas M&A transactions are common, and this is the most common exit for founders. So the main types of M&A deals are asset deals, stock sales, and mergers. Now, for an asset sale, that means the buyer is acquiring the assets and liabilities of the company directly. For a stock sale, that means the buyer is acquiring the entity, the overall entity. So they're going to acquire all the equity, and that will allow them to own the entity, and all the business will transfer with the entity. And a merger means you have two entities merging together. There's all different sorts of ways you can structure mergers, but that's essentially it. The two corporate entities are merging to become one final entity at the end of the day. So, today we're going to talk about the due diligence path, the due diligence part of the transaction. And for most players in a transaction, the due diligence is the phase where the deal gets real. So, to talk you through sort of the high-level deal process, we start with the letter of intent or the term sheet or the heads of term, memorandum of understanding, what have you. It's a non-binding document that the parties sign at the beginning of the transaction process, and it sets forth the key terms of the deal, the purchase price, the expectations around working capital, if there's going to be an earnout, escrows, indemnity, and so on. That will be captured in the letter of intent, and that will be non-binding for the most part. Most provisions in the LOI are non-binding. Once that's signed, the due diligence begins in earnest. Now, the buyer might start to do some due diligence prior to signing the LOI, but they usually don't really dig in until that is actually signed. While the due diligence process is going on, the parties are also negotiating the definitive agreements. Now, these are the agreements that will be binding. When they're signed, they are binding. So those agreements, the purchase agreement, an escrow agreement, what have you, non-compete agreements, all the agreements that make up the transaction documents, they will be negotiated in while the due diligence is going on, and the due diligence will impact what is in those documents to an extent. Once the due diligence is complete, once the definitive agreements are negotiated and ready to be signed, the parties proceed to signing and closing. So that's typically how an M&A process will proceed. Okay, so due diligence. So one thing I will just say is that everybody underestimates how much work is involved here. Buyers typically want to do a really deep dive into the target company, whether it's a deal for $1 million or a deal for $100 million. Buyers want to know what they're getting themselves into. So they typically want to do a deep dive into the target company. And due diligence is going to cover legal, it's going to cover financial, operational, commercial, and a buyer will often bring in teams to work on all these pieces of the due diligence. Now, our talk today is going to really focus on the legal piece. I'm a lawyer. That's usually what I do in an M&A transaction is cover the legal aspects, obviously. But just know there's a lot of overlap between the legal due diligence and these other aspects as well. We'll go into this in way more detail, but for the legal, we're covering the corporate structure, IP, litigation, contracts, regulatory, real estate, environmental, insurance, a lot of stuff. For the financial due diligence, they're going to want to dig into the financial statements, the tax returns, the debt of the company, revenues, and so on. In operational, they're going to want to look at your leases, your employees, your IT systems, your key processes, facilities, and so on. And then in the commercial piece, they're going to want to look at who your customers are, who your suppliers are, where do you sit in the market, what's the pipeline, and the competitive landscape and your growth potential as well. So this is sort of broadly what the whole due diligence process will cover. And obviously, deal size impacts on how, deep parties go, but, just generally know that the due diligence is going to be a lot of work and it's going to take a lot of time and effort. So I see we have a question here, so I'll quickly have a look. Oh, great. Nice to see you, Brian. Thanks for joining. Okay, I'll keep moving on. And folks, feel free to put questions in the chat as I go along if that's helpful. Okay, moving on to the next slide. Okay, the due diligence checklist. So you've signed your LOI, and then the next sort of document in the process is a due diligence checklist that typically comes from the buyer's legal counsel, and that's going to cover all the areas we touched on the previous slide, and on the legal side, it will drill down into the categories I have down the bottom here. These are usually covered in the due diligence checklist, and there's usually a whole bunch of questions under each of these subheadings. Now, a due diligence checklist, they're usually anywhere from 10 pages to 30 pages. And usually what happens is the buyer's counsel serves them up and the seller freaks out because they're like, what are you talking about? I thought we already had a deal. And now they're shocked that they have to go through this extensive due diligence process. I always advise my seller clients to just lean into the process. You're not going to be able to get out of it. You're going to have to give the buyer what they're looking for. And it's a helpful process overall at the end of the day. So you get this very comprehensive checklist, you work through it all, you cover all the answers, and while you're going through answering the checklist, you're gathering documentation and you're uploading it to a data room. So that's sort of the first step from the seller's perspective. They gather all this documentation and they put it into a data room, and then the buyer starts reviewing it, the buyer's legal counsel starts reviewing it. Just one other thing to add, I've got all these sections down here, the corporate piece, capitalization, IP, contracts, litigation, so on. Just know that AI is now a serious category in due diligence as well. So the buyers will want to know how the target is implementing AI in their business, what sort of policies they have around AI, what kind of licenses they're using, models, and so on. So just know that that is now a very common piece of due diligence as well. And over on here, I've got over on the other side of the slide, I've got a column here on why founders should care. So once you're in the deal process, you have to go through this due diligence process. You're not going to be able to get out of it, and we'll talk about that more. Why it's important to just cooperate and work through the process best you can as we go along. But for those people who perhaps aren't actually in the sale process yet, but are thinking that this is something they want to do in the next year or two, it can be a good idea to get your hands on a due diligence checklist and do a bit of a self-audit, or perhaps proactively start sort of put together an internal data room. I mean, obviously you want to be very careful in who you would give access to that data room, but you can gather things like your incorporation documents and your board minutes and your stockholder minutes, stockholder meeting minutes, and you can kind of gather information and just have that in a place. So when the time comes when you are going to do an exit, you've at least got a little bit of a head start on the process, and perhaps you can, identify gaps and fix them proactively. And I'll also say this can be helpful, a helpful process if you're looking to raise money. So if you're doing an equity financing round, investors will want to do due diligence on you as well. So it can be a helpful process to sort of think about and maybe put a few things in place, even if you're not quite ready to go down the M&A path yet. So I'm just going to check on the chat here and see if there's questions. Okay, just wondering if we can find the recording later. Yeah, Derek, I think Founders Bay, I'm pretty sure they record all these, and you should be able to get access to the recording. And also feel free to reach out to me via LinkedIn or my email, and I can send you the slides if that's helpful too. And that goes for everyone, of course. If you would like a copy of the slides afterwards, just email me and I'll send them to you. Okay, moving along. All right, so just talking from the seller's side, from the target company side for a minute. So the due diligence process serves two main reasons why you want to do it. So the first is the data room. We've talked about that a bit. You get this giant checklist from the Buyers Council. You're going through it, you're gathering documents, you're creating a data room, you're uploading all the documents that they want to see into this data room. When you're doing that, you're going to want to make sure you organize it in a way that's easy to understand. Sometimes when I go into a data room and it's just a mess of documents everywhere and I have no idea what it's all about, it's like it just adds time and confusion to the process. So, for the folks on the seller side, if you can, like, try and have folders and say, like, this is the folder with the corporate documents, this is the folder with our financial statements, and, just make it easy for the people to review to sort of understand where things are. You also want to be careful with who you give access to your data room. Obviously, this is your company's super confidential information. You don't want to just let anyone have access to it. But then, of course, you do need to let the buyers, advisors and legal counsel review. So, just make sure you give appropriate folks access. Now, there's a whole bunch of companies that provide these data room services. I mean, you can just use a Google Drive or a Dropbox or what have you, but there is a whole bunch of companies that can help you with making sure the appropriate people have access and keeping the information confidential and so on. And yeah, as you go through the process, and the buyer's reviewing, they'll probably send supplemental requests. And, it's sort of best practices. As soon as you get those supplemental requests in, you turn around and answer as quickly as you can. And I know sometimes it can get very frustrating. You've just answered this giant checklist. Now they keep having follow-up questions, and people are like, oh my God, I still have my actual work to do. So it can be very frustrating. But I always advise my seller clients to just try and remain patient and just keep moving forward as best you can with it, even though it is often a very heavy lift to get the buyer everything they want to see. Now, on the flip side of the data room, the other piece here is the disclosure schedules. We'll talk more about the reps and warranties and indemnities and so on. But at the end of the day, all this due diligence information that's being gathered is going to relate to the reps and warranties that are in the purchase agreement. The purchase agreement for the transaction is going to include a long list of reps and warranties about the various aspects of the business. They're going to have reps around your incorporation, your cap table, your contracts, your employees, your employee benefits, your taxes, the whole gamut. There's going to be a representation in the purchase agreement that directly ties to that due diligence category. So you need to make sure those reps and warranties are true statements from the seller's perspective. And to the extent that they are not true statements, you are able to go through this process called where you disclose, and you have the disclosure schedules for that. So you have a certain rep and warranty, and then it'll tie to a disclosure schedule where basically you're saying, this representation is true, except for what I have listed on this disclosure schedule. And then disclosure schedules are also used for things like listing out employees and listing out contracts, and maybe you include your cap table and things like that. So you're going through the sort of data room process, due diligence checklist process, and you're gathering all that information as a seller, and then you're going to turn around and use all that information to prepare your disclosure schedules. And obviously your legal counsel will work with you closely on this. The disclosure schedules are your sort of best source of protection in a transaction for sellers. So even though it is like a really involved process and it takes a lot of time, this is sort of the most important piece of a transaction in many ways to protect the seller. I mean, obviously you want to have a purchase agreement that protects your interests as well, but the disclosure schedules give you a lot of opportunity to mitigate the risk of the transaction. So, all right, I will quickly check to, oh, sorry, I'm just going to check to see the questions in the chat. Okay, I'll quickly type my email here, and then I'll share it at the end as well. Okay. Okay, great. Folks just want a copy of the slides. No questions yet? Okay, all right. I'm just going to have a quick sip of water here. Okay, now from the buyer's side. So we just talked about the seller's side, now on the buyer's side. So say you're a startup and you're looking to acquire one of your competitors or a company that you think might complement what you're doing. Or you encountered, a founder and you're like, this person is awesome. I want them to come and work for our startup, but they've got a business. So you might do something that what's called an acqui-hire, where you acquire that person's business, but you're really actually just acquiring the right to work with them and their IP. So a lot of startups and your founders, like M&A, is on their radar as well. So if you're on the buyer side, this is how due diligence works for you. You're going to send over that long checklist, and then as the seller fills out the data room, you're going to go through and look through all those materials. And you're going to look at what are the gaps, what are the red flags, what documents are missing, what do I want to drill down in and learn more about? What sort of risks and liabilities does this business have, and what's it going to bring to us when we acquire this business? So that's just sort of your data in process. You're going through there, and your lawyers might produce a due diligence report or a due diligence memo, or you might do one internally as well. And then on the flip side, with the disclosure schedules, so the seller will prepare the disclosure schedules, but as the buyer, you'll go through it and you'll review it. You'll say, oh, okay, like I see the sellers, disclose this piece of litigation. What's this all about? And it'll give you a chance to sort of, you can look into that and see if that's something you're willing to accept the risk on or not. And all the different sorts of disclosures. Maybe they've got like 50 contracts listed on there with respect to their contracts representation. So you go through those contracts and see what those contracts are, what kind of risks are associated with them, and if that's something you're willing to take on. Now, as the buyer goes through and they sort of identify things in the due diligence that maybe they're not comfortable with, that doesn't necessarily mean the deal is off, although sometimes it does. But usually it means we're going to draft something in the purchase agreement to deal with it. And that might be, say, the litigation example I gave. So usually if a piece of litigation comes up, we might want to have an escrow and hold some of the purchase price monies back into that escrow. So if that litigation does cause a liability that's sort of more than what they're expecting, they have the escrow to make the indemnification claim against. We might also negotiate a special indemnity. We just say, if anything comes up with respect to this litigation, you guys are covering it. So you have like a special indemnity for that situation. And sometimes we're just reducing the purchase price. So it's a whole sort of gamut of how things that you come across in due diligence might impact how you negotiate the deal terms. And then you might vary from where you were in the LOI to what's in the actual definitive purchase agreements based on what you discover through the due diligence process and the disclosure schedules process. So I'll pause for a moment and check the chat. Okay, all good. All right. Okay, and I'll talk here a little bit about the reps and warranties, and indemnity. So in the purchase agreement, these areas make up a large chunk of your purchase agreement. Whether it's an asset deal, a stock deal, or a merger, they're all going to include reps and warranties, and they're all going to have an indemnification section, most likely. It's pretty rare if you don't have these provisions, and a big red flag for both sides. So the reps and warranties, like I said, there's going to be a representation on each aspect of the business, which ties to the due diligence. You're going to cover, the corporate matters, the IP, the contracts, litigation, everything's going to be, there's going to be a rep and warranty for every sort of aspect of the business. And that ties to the indemnity. So if it turns out that one of these representations and warranties is incorrect, the buyer has the indemnity to rely on where it sets forth how they would make a claim. And it goes both ways often. There's often a seller indemnity and a buyer indemnity. The buyers do give reps and warranties as well in transactions. And the indemnity is broader than just the reps and warranties. It goes to the deal covenants as well, but the reps and warranties is a big piece of the indemnification piece. And I won't talk too much about indemnity today. It is a pretty complex topic that perhaps deserves its own workshop. But just know that, when you're looking at an indemnity, you're going to negotiate the survival period. How long after closing can the parties make a claim on the reps? Sometimes there's certain reps that you can make a claim within 12 months, and others it's statute of limitations or 5 years. It's a negotiated point, the survival period. So. And then the caps, what's going to be the cap on the indemnity? For certain reps and warranties, it might just be, if there's a claim, it's capped at 10% of the purchase price or 20% of the purchase price. For other types of reps and warranties, it may be the full purchase price. You can make a claim up to the full amount of the purchase price. And, if there's fraud or misrepresentation, willful misrepresentation, something like that, it might even be uncapped. And then, we talked a little bit before about escrows and holdbacks. Sometimes the buyers, will hold back a piece of the purchase price or put it into an escrow account. So if there is a claim, they can draw from that escrow and so on, rather than having to go back to the seller directly. Okay. I'll keep plowing forward. All right. So I'm going to focus now on a few key areas of due diligence. I'll just take a sip of water here. Thanks for bearing with me here. All right. So intellectual property. I do a lot of M&A transactions for tech companies, and IP is really the key asset most buyers are going for in these types of transactions. And any type of business, really, IP is a big piece of it, but particularly for tech companies. And I'm not just talking about your registered IP like trademarks, patents, copyrights, domain names, etc. But the broad sort of concept of IP, your software, your designs, your business plans, your all that confidential information, your customers lists, your AI models, and all those types of things we're going to be looking at. Open source licenses is a big piece of M&A due diligence. And to that point, some buyers want to do what's called a black duck review, where this is the company's name, I think they're called Black Duck. They can come in and have a look and assess all the open source that you've used in your tech. And that can be helpful to buyers. So that's a piece of it. Another important piece of the IP due diligence is the invention assignment agreements. So this is your PIIAAs or your CIIAAs, your proprietary information and invention assignment agreements, for all startups and all companies. Really, you want your employees and contractors who are coming in to sign one of these. These are reviewed in the transaction, in the due diligence process by the buyer. They'll go through and check each one of these for each person who's worked at your company. And they'll want to see them in place for everyone. And to the extent you don't have these in place, they'll often ask you to go and get them. So, I was just working on a transaction now where they were missing, the company had been around for like 5 years, and they were probably missing, 10 of these agreements out of, say, 100 people who'd come through the doors of the startup over the course of its business life. And we had to go back, I was representing the seller, we had to go back and find all those people and get them to sign one of these agreements, even though they'd left the company. And this comes up all the time. So I would just say to you, a great way to prep for your M&A exit is to get into the habit of having everyone sign one of these when they onboard. And if you don't have everyone if everyone doesn't have one signed right now, go and get them. And if you need help, finding a form of these IP assignment agreements, reach out to your lawyer, reach out to me, and we can get you a form to use for your business. And the reason all this is important is that the buyer wants to make sure that you own the IP that you're using in your company. So you either have to own it or you have to have the right to use it, which means you have a license in place to use it. So, particularly important with AI right now, like, what sort of AI licenses do you have in place for your business? Or, what are you developing in that regard? What do you own? What are you licensing? Is there any third-party IP embedded in your product? So it's really important that you can show that you own your IP or have the right to use it. And that's going to be a big part of the due diligence process. And so those IP assignments, which I know I'm banging on about a bit, but I assure you they are very important in the diligence process. those agreements clearly set forth that while you're working for the company, what the employee or the contractor was working on is owned by the company. And they usually also include information, provisions around protecting confidential information, and when you leave the company, you'll return all the confidential information to the company and things like that. So it's really important to have these in place, particularly if you're a tech company. Okay. And yes, I have seen deals fall over because they couldn't get the IP assignment from a former founder who left in a dispute and refused to sign it, even though they probably would have got something out of the exit. So just make sure you have these in place. It can be a deal killer. A buyer doesn't want to buy a company that they don't, own, that doesn't own its IP. And yes, sometimes they are willing to waive these types of things, but often they're not. So, okay. All right, capitalization. This is another really big piece of due diligence, which when it's done well, it can be great and it just makes the deal go really smooth and easy. And when it's done poorly, it can be a complete disaster and a nightmare. So you want to make sure you have a cap table that is clean and fully documented. And by that, what I mean is, you have a cap table, you have all your entries for all your types of equity that the company's granted, whether that be common stock, preferred stock, options, warrants, safes, convertible notes, anything and everything you've issued, have that in the cap table and have it clear, the party names, the amount of the stock or options, what have you, have it all clearly set out and have documentation to support it all. And included in that documentation is also the necessary corporate approvals for the issuance. So whether it's a board approval or a stockholder approval, you need to have those for each issuance. And you also need to have the agreements, whether it's a stock purchase agreement or a safe or your option grant documentation, you need to have the paperwork in place to back up the entries in the cap table. You also are going to need those 409A valuations for options. So every time your company's granting options, you need to set the fair market value for the exercise price for those options. And the best way to do that is to get a 409A valuation. And if you have any vesting schedules, usually employees and founders have some sort of vesting, I'd include that in the cap table too, and also have that in your restricted stock agreements and so on. And look, the reason why this is important is because at the end of the day, the equity holders want to get paid at the end of the M&A transaction. And when you have a transaction where it's all properly done and it's been maintained all along, it just makes closing super easy. It's very clear, you can put the waterfall together from the cap table and it's all great and easy. When the cap table is a mess and that documentation isn't there to back it up and it's not clear what the option exercise prices are and things like that, it can be a real nightmare to try and fix while you're closing a transaction. And yeah, it can be a real headache. So yeah, I would just say, just do your cap table correctly. have your lawyer help you. Use Carta, use Pulley, Capita. There's all sorts of cap table management companies out there. Get this one right, and it'll make your M&A exit, much easy. Get this wrong, and it can make it really hard. Okay, I'll do a quick pause, see if we've got any questions in the chat. No questions, okay. Hopefully I'm not putting you all to sleep out there. Okay. Litigation. So yeah, when it comes to litigation, on the sell side, just disclose it all. Past litigation, present litigation, threatened litigation, make sure you get it on the disclosure schedules. Government investigations, tax audits, your best protection is just telling the buyer it's there. They're going to find out anyway. and it's just better you deal with it up front. Sometimes on a deal, the buyer will say, you have to get this settled before we can close. We can't go to closing where you've got this litigation out there. And that can put a lot of pressure, to maybe you end up settling on terms that you don't necessarily want to. I've seen that happen a few times. Sometimes the buyers are like, okay, give us a special indemnity and, we'll figure out a way to manage this litigation going forward. It can be different if there's considerations, if there's an asset deal or a stock deal and so on. But yeah, so if you've had an employee dispute, say you fired someone and then a dispute came out of it, if you've received cease and desist letters, if you've had a customer that's been upset and it's threatened to sue, if you've had a regulatory agency send you a notice that says, you may have breached XYZ permit or license or something like that, all that sort of stuff. Make sure you disclose when you're a seller, and then a buyer, you work with your advisors to consider how you want to deal with it. Okay, just checking what we've got in the chat here. Okay, has anyone here used Carta or an alternative that they like? Yeah, so a lot of my clients use Carta or Pulley, and then another new player in the space is a company called Capita, and they're just a new product in this space that I've met the folks there a few times. And then, companies like Fidelity and JP Morgan, they're all offering cap table management services in their sort of startup programs as well. Carta's sort of the most, the old school one. Lots of folks use Carta. I think all the services are pretty good. You can, of course, just have an Excel spreadsheet and manage it yourself, which can work if there's just sort of one or two of you. But once you start issuing safes and options, I think using a cap table management service can be really helpful. And a lot of them will provide those 409A valuations for you as part of their service. So that can be really helpful. But yeah, feel free to ping me if you want to talk about it some more, and I can give you some contacts at these companies to reach out to. But I think they're a great idea to use a cap table management service. And Vijay, in response to your question here about is there a actionable list? I can share these slides with you at the end if you just reach out and email me. And then if you want to have a look at a due diligence checklist or something like that, reach out to me and I can find you an example to take a look at. And I will talk on some action items you can do in the presentation as well. Okay, we have a question here. What specific steps do you recommend to ensure AI-generated audit reports carry enough legal weight? Yeah, great question. So, this is an evolving area of what's going to be, good enough, or whatever is the expression, for an AI audit report. I think it's sort of case by case still at this juncture in our new AI world, and it will really, for a large part, yes, the lawyers will be looking at everything and considering it, but it'll really be a conversation between the business principals. Like, the seller can explain, this is what we're doing with AI, these are our licenses, these are our models, et cetera, et cetera. This is the AI we use in our product, this is what's embedded in our product, and the buyer will either be comfortable with that or they won't be comfortable with it. So I don't know if that sort of helps answer that question, but yeah, it's sort of, I wouldn't say there's like a definitive checklist yet on sort of the audit reports there probably is if there's a serious problem, but to the extent you're like complying with your license and, paying for it and, it just sort of, it really just sort of depends on what the business principals are comfortable with. And then another question here. Which single legal red flag in a startup's equity or IP history is the most likely to derail an exit at the last minute? I've seen the gambit of this. Things with equity, probably the most common thing to cause a deal to sort of derail is if you had a co-founder dispute and it wasn't resolved properly. So you've got, say, a co-founder who worked on the company for a while and they hold a lot of the company's equity and they leave and there's a dispute and, maybe the company doesn't buy back their stock or, you know, I don't know, there's sort of all the ways it can land with a co-founder dispute. And then you're going to do an M&A transaction and you need that person to vote on the transaction because they hold so much of the company's equity. So I would just say to that point that if you have a co-founder and they leave, whether amicably or in a dispute, make sure, think about buying back their stock. If you can, you may not be able to. It's not like you just turn around and buy back stock easily, but maybe think about doing that, or have vesting in place for the founders, which will make it easier to claw back their stock, or come to some sort of settlement or agreement about how you're going to vote their equity down the road so they can't derail a transaction. And IP, as long as you're not like stealing someone's IP, it's as long as you've got those IP assignments in place, you're usually pretty good. Yeah, so don't steal anyone's IP. If you're using IP, get a license for it. If you're using third-party IP, get a license and have those IP assignments in place with all your team members, and that usually keeps it pretty clean. Yeah. All right, I'll keep plowing on. Let me know if I didn't answer your questions. Okay, commercial contracts in debt. I probably should have had a separate slide for
Oh,
each of these.
sorry. I just had everyone's mics muted, but I just unmuted you all if anyone was trying to unmute. So if you have any questions, you can go ahead and unmute your mic now and ask.
Yeah, I can wait a second if anyone wants to jump in right now. All right, I'll keep plowing on, but feel free to interrupt me. I know it can get a little bit boring with someone just droning on, so don't hesitate to jump in if you like. Yeah, so like I was saying, commercial contracts and debt, these should actually both really have their own schedule, own slide. They're both really big parts of the due diligence process. The commercial contracts often is the biggest piece of the due diligence. And depending on the buyer, they might want to cover, like they might want to look at every customer agreement you have, every vendor agreement, every supplier agreement, all your strategic partnership and business development channels and things like that. They want to look at your lease agreements and employment agreements and so on and so on. So this can be a really big piece of the due diligence review. Good news for the clients. The lawyers typically review the contracts and go through them in this regard. And what we're looking for when we're looking at those contracts. Well, firstly, are there any provisions in there that prevent the contract from being assigned? If you're having an asset sale, you need to assign all the contracts. And often contracts include a provision that says you can't assign this contract without the other party's consent. Or if you're having a transaction where there's a change of control, like a stock sale or a merger, a lot of contracts include a provision that say, if you're doing that, you need to get our consent. And so first of all, we're looking for those types of provisions. Secondly, we're looking, is this contract expired or about to expire, or can it just be terminated, for convenience? Can this super important customer just turn around and cancel this agreement on 10 days notice. What's the indemnity clauses look like in these contracts? Is there any exclusivity clauses, heaven forbid? So things like that. The lawyers will look through the contracts and review for those provisions. And then often the disclosure schedules will require, a long list of the company's contracts. So that is a big piece of the diligence review on both sides, buy side and sell side. Debt is also a really big thing. And debt is important for the reps and warranties, but also there will likely be a provision in the purchase agreement around working capital. And the debt will likely play into the purchase price adjustment, working capital, net working capital adjustment, things like that. So we're going to want to look at, are there any loans, lines of credit, anything from a bank, any venture capital debt, well, safes are not debt, so I don't know why I have that listed there. Sorry, that should not be there. Sometimes they're considered that in finance, in your financial statements, but they're not actually debt, they're equity. Convertible notes are debt, they're debt and they're equity. So just keep that in mind. Have the founders given any personal guarantees for the business's loans? That's pretty common for startups, especially with leases and things like that. What sort of liens are out there? Are there any UCC filings? Is there any collateral of the company that's being used to back up the loan that the company has? And what about intercompany loans? Sometimes, you'll have a parent company that's your Delaware C Corporation, and you'll have an operating company in India or in Australia or Singapore or what have you. Is there going to be loans between those, within the company that we need to take a look at? Okay, I'm going to take a look at the chat again. I see we've got some questions up here. Oh, still can't unmute myself. Okay. Okay. Vijay, did you want to ask a question? Should I pause or?
No, I mean, I lost the track, to be very honest. I
Okay,
apologize.
no
No,
problem.
but excellent. Would it be possible also to request a meeting with you if that would be okay with you,
Yeah,
Ellisha?
absolutely. Yeah, feel free to email me
Mhm.
and I can send you a link to my calendar and then we can find a time to chat. But yeah, very happy to have a sidebar with anyone on the the webinar today. Feel free to reach out to me. I put my email in there, but you can find me on LinkedIn too, and I check that usually once a day or a couple times a week. So yeah, please feel free to reach out. Very happy to have one-on-ones as well.